Today, we are diving deep into the world of sales contracts. But we're not looking at it from the seller side. We're looking at what can be a buyer's fatal error.
Mm-hmm.
We're exploring that critical moment right after you, the buyer, accept some goods, but then you discover a defect. And the question isn't whether the seller messed up.
Right.
It's whether you, the buyer, perform this one crucial step that allows you to recover any damages at all. So just imagine this. You bought something, it broke, the seller tried to fix it, and it broke again. But instead of picking up the phone, you decide, I'll just wait. 6 months go by, you hire a lawyer, you're confident. So let's unpack that. Why is that strategy almost always a guaranteed loss? Why is your silence a contract killer?
Well, we're going to be drilling into UCC Section 2607.
The Uniform Commercial Code.
Exactly. It's the law that governs sales of goods pretty much everywhere in the U.S. And specifically, we're looking at subsection 3A, which sets up this hard and fast requirement for the buyer to notify the seller of a breach. For you, the listener, the mission here is to understand why this notice is what lawyers call a condition precedent to recovery, which means if you miss this step or you wait too long, your lawsuit is basically dead before it even starts. We're going to use the case of Parker v. Belfort to really model a rigorous element-by-element analysis of this rule.
All right, so before we get into the facts of Parker, let's just nail down the doctrine. What is the fundamental black-letter rule here? What are a buyer's obligations once they've accepted a product and then discover a flaw?
The law is pretty unforgiving. It's UCC Section 2-6073A. And the statute says, and I'm quoting here, where a tender has been accepted, the buyer must, within a reasonable time after he discovers or should have discovered any breach, notify the seller of breach.
Must, not should.
Must. And here's the core takeaway, the thing courts stress over and over. This notice requirement is a condition precedent. If the buyer fails to meet that condition, if the notice is too late or it's not clear enough, the court never even gets to the question of whether the seller's warranty was breached.
So you could have a completely defective product, but you get nothing.
Absolutely nothing. Your case is over.
That seems incredibly harsh. I mean, why does the law care so much about this one phone call or this one letter? What's the policy justification? Why can't just filing the lawsuit be the notice?
Because the whole point of the UCC is to promote, efficiency and good faith. It wants to solve problems, not create litigation. So notice serves two really critical functions. First, it just opens the door for settlement through negotiation.
Right, a chance to talk it out.
A seller might much rather just replace the product than spend years and a fortune on legal fees. Second, and this is crucial, proper notice gives the seller an ample opportunity to cure the defect. They need a chance to inspect the goods, to investigate the claim, to figure out what went wrong.
While the evidence is still fresh.
Exactly. If you wait 6 months to sue, they've lost that chance to fix it, and it really prejudices their ability to defend themselves.
Okay, so it's about communication and mitigation, not just springing a legal trap. So let's see this doctrine in action. Let's analyze Parker v. Belfort. First, what are the legally dispositive facts?
Okay, so Parker buys a new 1979 Ford F-100 pickup from Belfort. Almost right away, he starts complaining about really bad tire wear. He had to replace them after only 4,000 miles.
That's not normal.
Not at all. So Belfort tries to cure the problem. They send him to an outside alignment shop. But here are the key facts. The work at the alignment shop did not fix the problem. But Parker, he never returned the truck to Belfort, and he never made any other complaint.
He just stayed silent.
Total silence. For 6 months. And then,
Oh.
boom, he files a lawsuit on July 1st, 1980. And it was only after the suit was filed that an inspection found the real problem, a defective wheel housing.
And what was the core legal issue that the Alabama Supreme Court had to resolve here?
The precise legal question was whether Parker gave sufficient notice of the continuing breach. After the first repair failed. Did he meet that condition precedent, or was the trial court right to just throw his case out because he didn't?
So what rule of law did the court apply? Let's get the full black-letter rule and then break it down into its testable elements.
So they applied UCC Section 26073A, but with a very important twist for the situation. They said that after an initial repair attempt fails, the buyer has to provide a second notice about the continuing defect. So the elements for the buyer to win here would be, 1, they accepted the goods and found a breach. 2, they gave official notice that the attempted cure had failed. 3, that notice was within a reasonable time. And 4, the notice had to tell the seller a claim was coming and give them a new chance to fix it.
Thank you. Okay, now for the court's elemental analysis. Let's walk through this step by step. Let's start with that second element, the requirement of providing official notice that the cure failed. I mean, the seller already knew the truck had a problem, right? They tried to fix it. Why wasn't that enough?
That is the absolute heart of the case. And the court drew a very bright line. They said, yes, Bell Ford knew about the initial defect. They tried to fix it.
Right.
But in their mind, the problem was solved. They had fulfilled their duty. The court found that because Parker never contacted them again, the seller had no notice that their fix was a failure.
So Parker's silence basically told Bell Ford, everything's fine now.
Exactly. He let them believe the breach was resolved. So by not giving that second notification, hey, your fix didn't work, he completely failed that essential element.
Understood. That lack of communication after the failed repair was fatal. Okay, let's look at the third element, giving notice within a reasonable time. 6 months doesn't always seem like a crazy long time. How did the court handle the timing aspect?
Well, reasonable time under the UCC is always measured against those policy goals we talked about, mitigation, opportunity to cure. The court said waiting 6 months until you file a lawsuit was, by definition, unreasonable because it completely stripped Bell Ford of all its options. They lost the ability to inspect the truck right away, to call their own supplier, Ford Motor Company, while the issue was fresh, or to just say, you know what, let's take the truck back and give you a new one. The delay actively prevented the seller from minimizing their own damages.
And that leads right into the fourth element, doesn't it? The core purpose of notice giving the seller that opportunity to defend or cure.
It does. It ties it all together. The court emphasized that the whole point of notice is to warn the seller that a claim will be made and give them a chance to prepare or to settle. Bell Ford only learned about this continuing claim when a summons showed up.
6 months too late.
Way too late. By then, the economic opportunity to fix the wheel housing before more damage happened was gone. It was lost forever. So because he failed on all of these communication-based elements, the buyer's failure was absolute.
So after breaking down all those elements, what was the court's final conclusion?
The Supreme Court affirmed the directed verdict for Bell Ford. It was an easy call for them. They said the record had no evidence, literally zero, that Parker ever gave notice of the continuing defect before he filed that lawsuit. And since he failed to satisfy that condition precedent, the claims against both Bell Ford and Ford Motor Company had to fail.
Wow. So it's not just about telling them once, it's about telling them again that the fix didn't work. That is a deadly nuance. Okay,
Yeah.
Let's use a visceral hypothetical to really hammer this home.
Okay.
Let's say you buy a huge commercial deep fryer, and the first week it starts leaking flammable oil all over your kitchen floor. The seller sends a technician who just wipes it down and says, all fixed. But the next day it's leaking again, and you decide, I'm just going to keep using it for 9 months, risking a fire, losing all this expensive oil, and I'm not going to call the seller. Why does the Parker analysis guarantee you lose that claim?
Because you have intentionally denied the seller the opportunity to cure and to mitigate what is obviously a very dangerous situation. The second you see that oil leaking again, you have to re-trigger the notice requirement.
Immediately.
Immediately. By waiting 9 months, you're violating every single policy goal of the UCC. The seller is completely in the dark thinking their fix worked. You've denied them the chance to stop a massive damage claim by just replacing the unit or even telling you, hey, shut that thing down before you burn the building down. A court will see that as totally unreasonable behavior. Your failure to notify after that first failed cure attempt is the same as giving no notice at all. Your claim is gone.
This analysis really models exactly how these issues have to be broken down. So to wrap this up, for the listener who might be facing an exam or a real-world problem, what's that mandatory step-by-step diagnostic checklist we can pull from Parker?
This is your guaranteed path to issue spotting this. A 6-step framework. 1. Acceptance test. Did the buyer accept the goods? If yes, the UCC modus clock starts ticking. 2. Breach discovery. Did the buyer discover, or should they have discovered, a breach? 3. The first notice. Did the buyer give that initial official notice of the breach? 4, and this is the big one, the cure trap, the Parker killer. If the seller tried to cure, did the buyer provide a second notice that the cure failed? This is the point where so many of these cases fall apart.
The second notice. Got it.
5. Reasonable time test. Was the notice given in a time frame that allowed the seller to actually do something about it? And remember, filing a lawsuit months later is almost never considered reasonable.
And finally.
6. The verdict. If that timely notice of the breach, or especially of the failed cure, is missing, the seller wins. It's an unfulfilled condition precedent. It's a simple defense, but it is incredibly powerful.
So what does this all mean? I guess the big takeaway is that under the UCC, the buyer's duty to communicate is every bit as critical as the seller's duty to deliver a good product. Silence, especially after a so-called fix, is a contract killer.
It absolutely is. And here's a final thought for you to consider. If Parker had just sent one single certified letter right after that alignment failed, what specific difference do you think that one piece of paper would have made? Think about the value of the cure opportunity that his delay completely destroyed for the seller, and how that one simple action could have saved his entire case.